welcome to all the participants who have already joined. Our panel today is the 1, 2, 3, 4, 5 of us, maybe 1 or 2 who may join. Today, the idea is we've been through the Business Rescue Act, the provisions in the Act, and that now is available. We had a panel discussion on Friday. It's available on Facebook, where we go through the Act, and we also have the likes of Advocate Don Mahan, experts in the industry, who provide their input. So what we'd like to do today is not go through the Act in that much detail, but basically create an understanding of the Act through questions and answers. And what we'd obviously encourage is questions from the audience. You can post questions anonymously. So if you have any question that you may have, it would be helpful. If we don't receive questions, what we'll be doing is going through questions that have been raised in the past, and hopefully that'll also give you a better understanding of the Act. So I will give a brief overview of the Act, and then through the answering of questions, hopefully the details specific to your industry or to your company can be dealt with. So let me just make sure that the question and answer pane is open. I have it open, and we'll deal with them as they come in. Okay, so I mean, we've all heard business rescue. It's the topic of the day. Business rescue is what one needs in a crisis like this. We see that other countries are passing legislation similar to the business rescue provisions, and there is no need in South Africa for such legislation because the 2008 Act took care of that. Now, most importantly, when it comes to business rescue, what everybody is after is a moratorium on any claims. No, excuse me. The moratorium on claims effectively prevents or stays claims by creditors as against the company. The idea is to give you breathing space to allow for the restructuring of a company through a business rescue practitioner, and the implementation of a business rescue plan. The business rescue plan is compiled by a business rescue practitioner in conjunction with shareholders, stakeholders, creditors, and the like. And the idea is to work constructively together to find a middle ground so that the outcome is the lesser of various evils, or of all evils, in relation to the debtor-creditor relationships. If business rescue just simply cannot work, then one goes into the liquidation route. But what COBRA is doing everything in its power to ensure that liquidations do not take place. So I'm going to throw some questions to the panel, and I'll start with Ian. Ian, if you can just deal with an affected person and the context in relation to when it's relevant.
Thanks, Maurice. An affected person is defined as creditors, typically defined as creditors, shareholders, and employees of a company. It is literally everybody who is affected by the fact that the company is in business rescue. Shareholders are, well, creditors are the ones that we mostly deal with because creditors are the ones who are owed money by the company. So the creditor is a very important affected person, and the creditor is the one who ultimately votes on the business rescue plan. The additional affected persons are the employees, because obviously their jobs and livelihoods are at stake, and their jobs and livelihoods depend on the business rescue. And shareholders, of course, are affected persons as well, because they hold a stake in the company. They hold equity in the company, and when it comes to paying out dividends in a business rescue, the shareholders sit behind the creditors and the employees typically. And but if it's a successful business rescue, at the end of the day, the shareholders will obviously stand to benefit hugely from still having a business that works.
Great. When in your view, Ian, should a company go into business rescue as opposed to liquidation?
A company should certainly approach turnaround experts at the earliest possible signs of distress. And then the turnaround experts won't necessarily put it into business rescue straight away, but they will consult with the company as to, and they will have a finger on the pulse as to when the company should potentially go into business rescue. We try to avoid putting a company into business rescue for as long as possible. But having said that, the company needs to be consulting with credible turnaround experts for that to work. So the moment it goes into business rescue, it becomes a little bit more expensive, and the company is painted with, I'm not saying tainted, I'm saying painted with a label of business rescue. So, you know, and everybody out there has heard bad business rescue stories. I'm sure everybody in the audience has heard bad business rescue stories. That's why it is so critical to choose the right business rescue practitioner who you're going to work with, or the right turnaround expert who can advise you correctly. But approach a turnaround expert at the earliest possible signs of distress, and then he will advise you when to go into business rescue. That will avoid the possibility that you come to the party too late, or that you call for help too late, by which time it might be too late to save your company, and then it basically will go straight to liquidation.
And I think what's important there is what COBRA does is COBRA creates that ecosystem to avoid a business rescue by contacting the creditors and trying to get them into the ecosystem to deal with their creditors in turn. And then there's this cascading effect, which will hopefully avoid all businesses going into rescue.
Right. And you'll find that, you know, we had an instance the other day in a shopping center where, you know, we've already put one tenant into business rescue, and we've been approached by another key anchor tenant in that same shopping center. So now we are representing two of the key anchor tenants in that center, and we'll be dealing with landlords and so on. And that will obviously put us in a favorable position to deal with the landlords and so on.
Sure. I think just also at this point, it's important to just highlight that business rescue, you are obliged as a company to put business rescue to a vote. So importantly, business rescues can be initiated by the board by way of a simple resolution. It goes into business rescue on sending the docs to CIPC, and then you're in rescue, and a business rescue practitioner will get appointed. The moment you're financially distressed, and distressed is if it's conceivable, if it's likely that you will not be able to pay your debts within the ensuing 6 months. That's all it is. It's a very, very low bar. So if that's the case, you're obliged to put it to the vote. And if you do not vote in favor of business rescue, what you need to do is you need to send a notice to all the employees and creditors setting out why you've chosen not to go into business rescue. And one reason why that you can give to your creditors is the fact that you're in the ecosystem. So the idea is, I just want to have a look here, because I was working to settling a document here, and I would like to put up on the screen. So here we go. Let me share this. So the idea would be to send a notice, COBRA. So if you join the COBRA ecosystem, this goes to the creditors, and it's sent by you. We've joined the COBRA ecosystem. The COBRA War Room is a pro bono initiative, and it sets it out. Due to our financial distress caused by COVID, we are obliged to consider putting our company into business rescue in terms of Section 129, which we've decided not to do due to the fact that we've joined the COBRA ecosystem. Please join the COBRA ecosystem. They'll assist you in mediating a financial arrangement between you and the company within the ecosystem so as to ensure our continued survival. The idea is that they attempt to strike a balance between creditor and debtor relationships so that everyone keeps their heads above water, regard being had to each other's businesses' cash flow requirements. They can immediately assist, and we just got to insert the email address. So this is nice because this avoids business rescue. It avoids the stigma of business rescue. It creates that ecosystem that, well, it creates an ecosystem which justifies. It's a good reason to give to your creditors as to why you're not in business rescue. Okay, Peter, you there?
I am, Maurice. Hi.
Hi, how are you doing?
I'm good, and you?
Good. Generally, I think practically, I'd like to ask you a practical question, and that is in relation to how long the duration of business rescue proceedings and when they come to an end.
Maurice, I look in terms of the Act, bear in mind the Act is totally time driven. The practitioner has got 3 months essentially to publish a business rescue plan. Once the published plan is published, the time taken is then dictated by the terms of the plan. So you can get a fairly quick turnaround. In fact, you could get a turnaround of a plan being published before the 3-month deadline. The only difference with the 3-month deadline is thereafter the practitioner has to advise all the affected persons each month as to the progress, something that a lot of business rescue practitioners forget about. So creditors are left in the dark. But it is important for creditors to remember that if they contact the practitioner, he does have to give you that monthly report. And Maurice, it depends on the complications. We often go into a business rescue that we've got what we call a pre-pack, so pre-arranged possible sale of the business, possible sale of the assets, and that can be a fairly rapid turnaround in paying out the affected people. On the other hand, I've had one recently, which is a financial services company. Unfortunately, it was hit by fraud. And what I managed to do is issue new instruments to the creditors, and they're getting paid out over 3 years. However, I took the company out of rescue and put the control of the instruments in the hands of the body of creditors to make sure that the company did perform. So it really does depend on the individual case. We do have a history of one of the Chrysler companies, which has been in Chapter 11 in the US, similar to Chapter 6 here, whereby the company's been in rescue since the early 1930s. So it can be a situation where, a company's in for the long haul. In that it's a very unusual case. It's a matter of different trusts that would bring the company down if it came out of rescue. So they've just all agreed to leave it in Chapter 11 until this whole thing's resolved. Well, it's over nearly 100 years and it's still going. So I think that's an extreme case. We have had cases here where the business rescue practitioner lands up in litigation, which I say to Ian and myself when we're doing things, to me, that's almost a failure. You want to avoid litigation at all costs. Bear in mind, the other nice thing about the COBRA eco-environment is that it is totally negotiation between the parties. That's not to say in business rescue we don't take the same approach. It's a collaborative approach with all the parties trying to find the win-win situation. But unfortunately, as we all know, occasionally you get that 1 or 2 entities that decide to go on a litigious route, and then it can go on for a fairly long time. Sad because, well, good for the lawyers, of course, the money has been spent outside of the creditor's pool, and that's not to the benefit of the creditors. So yeah, very much depends on the case.
Peter, considering there's a moratorium, what kind of litigation are you speaking of?
Maurice, where creditors are forcing a particular vote in the plan, because what you were explaining is once the plan's published, it has to have a vote, and it needs 75% of the creditors voting on it. Broadly, most have to be independent. And what happens is when you've got 2 powerful groups of creditors, they start at each other, and you end up with a situation where one of the groups is insisting on a change to the plan, the other won't do the change, and the practitioner himself is advising both of them that it's not going to work. So it lands up in court because the practitioner is trying to force it through one creditor body I've got a hospital, I'm on the other side, unfortunately. There's a hospital in Midrand at the moment where this is exactly the case. It's been going on for a year. I can't think how many times we've been before the courts. And basically, trying to get injunctions against the passing of the plan, trying to push their agenda through. So it becomes extremely messy.
And one also have, I mean, we've experienced it, potential liquidators who want to convert a business rescue by way of a court application into a liquidation. Why? Because then the idea is in their minds to get appointed, and then they get the fees. Incidentally, just on fees, the fees are very, very different. A business rescue practitioner is paid by the hour depending on seniority, or a business rescue practitioner can enter into an agreement, for instance, a contingency fee agreement with the client, to structure the deal outside of an hourly rate. Now, liquidation is just set. It's the three separate asset classes: movables, cash, and immovables. And the commission is 3%, 6%, and 10%. So when you're talking, when you have a company with an NAV, let's say, of 100 million with only one asset, it doesn't make sense for a liquidator to be appointed unless there are disputes. Because when it comes to liquidation, the machinery of a liquidation, the investigative machinery, is far, far more powerful.
Thanks, Maurice. Can I just weigh in a little bit on Peter's discussion about litigation there? The courts are very eager to protect the sanctity of business rescue, for business, of the moratorium in business rescue. And there was a recent judgment where SA Airlink actually sued SAA once. This happened in January or February. Once SAA was already in business rescue. And it seems the courts don't look very favorably on that, on legal action against the company that is in business rescue. SA Airlink claimed that the commissions that SAA owed Airlink were actually the property of SA Airlink, as opposed to being a normal debtor-creditor relationship. And one of the things that the judge said when he ruled was that, has SA Airlink in this litigation taken cognizance of how this will affect the SAA business rescue? And will this litigation not affect the SAA business rescue in a negative way? And I think that was fairly groundbreaking in recognizing the sanctity and protecting the moratorium of the business rescue legal framework. There's another interesting. I just want to. There's another interesting matter that Peter and I are actually involved with at the moment, where shareholders are fighting against each other, and there's two groups of shareholders fighting against each other. And Peter is very well known and trusted by the one group of shareholders, and I'm well known and trusted by the other group of shareholders. And this is kind of a perfect way, having put it into business rescue and appointed Peter and I as joint business rescue practitioners. This is kind of a perfect way to bridge the gap, and hopefully all the litigation will fall away. So business rescue can also be a savior in that it can, if managed properly and by responsible practitioners, it can actually cause a lot of problems to go away.
Yeah, great. Thanks for that. What powers do you guys have as business rescue practitioners?
Maurice, well, I think you've already covered the issue with the insolvency practitioners. The business rescue practitioner, though, has absolute control of the board. He's a court appointee in control of the board. So he has absolute control of the business. As I think both Ian and I have said, we try and work on a collaborative basis with the board. But in a case where that's not possible, the practitioner can literally run the business. Full fiduciary duties, no different from those of a director. Within the Act, so that's the control of the business, and that's absolutely 100% right, because what you're trying to do, let's remind ourselves, is rescue the business. As regards the investigative powers, the practitioner is obligated in terms of the Act to investigate anything that he thinks that the company has done or is doing, which is contrary to legislation, whatever that legislation might be. He's then obligated to instruct management to cease doing whatever they're doing, and then he has to report it to a relevant authority. The Act is not clear on to whom it needs to be reported, but for example, my fraud financial services case, I had to report it to what was then the FSB, now the FSCA. So, but that's not, you know, the liquidator does have the power of summonsing and can call for what we call a 417 inquiry, which is normally held before a retired judge, where things are investigated at a far deeper level. But I think the purpose of Chapter 6 is not to get bogged down with, you know, litigation against wrongdoers at a level which then distracts from, which often happens in a liquidation, of course, distracts from the issue, which is what is the end goal? And the end goal is to get this business to survive and hand back a healthy business to the creditors. To say that, of course, we must remember that if you can't do that, if you decide fairly early on that this thing really is not rescuable, business rescue does give you the opportunity to do a structured sale of the assets, i.e. not under the auctioneer's hammer. And as we all know, in a liquidation, the auctioneer's hammer normally means bargain discount prices, whereas in rescue, you can do a structured sale whereby you're given time to extricate best value for the assets and thereby give a better return, which is what your target is, to give a better return to creditors than would be the case in liquidation.
What happens, Peter, if the company requires financing to keep going?
Well, Maurice, that's a critical question. It's what we call post-commencement finance, or PCF. The main players at the moment in this market are the banks or the shareholders. Obviously, first port of call would always be to go to the shareholders. And if they, remember, the directors have to say that they believe this is definitely rescuable, if I could use that word. And so there should be, assuming the directors, medium-sized to small company directors are normally shareholders, assuming that they have that belief, then hopefully they can put more money in. Unfortunately, very often the shareholders have already done that. So by the time it goes into rescue, the coffers are dry regarding the shareholders. It then becomes critical to approach the banks or potential other funders or somebody that's prepared to invest in the company. We run a corporate finance practice as well, so we are in touch with funders and people that are willing to take on slightly risky investments. And because obviously if we don't get PCF, you're not going to be able to pay anybody, including the practitioner. For that very reason, Ian and I have a very strong belief that one of the most important relationships beyond working with the creditors is the banks. So we will never, obviously sometimes you're going to get a banker that is just going to be obnoxious, but we will never, by choice, take on the banks. We work with them. And most of the banks, well, not most, all of the banks now have specific business rescue departments, not always called that, but in the old days, they just had recovery departments, which tried to recover the debt and then handed it over to their internal legal, who went straight to the liquidators. Whereas the business rescue units are trying their damnedest to help. And in that scenario, we try and raise funding out of them, bearing in mind the practitioner has access to all the assets of the company to use as security. So we can offer any potential funder, often the banks, with new security to cover their risk. The other good thing with the PCF providers is that they are super preference. So they stand in front of everybody else other than the practitioner himself for his outstanding fees. So they're number 2 in line for anything that they've put in to the company post-rescue. And that includes any organizations, any creditors that had security prior to the rescue. They stand in 3rd in line. And then obviously 4th is the normal creditors and 5th is the shareholders themselves.
Now, what if the business goes into liquidation?
If the business goes into liquidation, then the normal liquidation rules apply. So then that changes. The practitioner is no longer super preferent. There has been cases on that. The practitioner becomes an unsecured creditor unless the practitioner managed to get the creditors to agree. Remember, the creditors have to agree the practitioner's income. So if the practitioner managed to get security for his fees, that's fine. But then the normal liquidation rules apply. So secured creditors first, depending on the nature of the security, then the preferent creditors, employees, SARS, and then the unsecured concurrent creditors. And everybody would fall into that category. But if it goes into liquidation, you have given post-commencement security to a creditor, then that security still stands in liquidation. Unless, of course,
and it stands above, and the post-commencement secured creditor ranks above the other secured creditors.
In liquidation, yes.
Liquidation,
unless,
yeah.
of course, the liquidators and could well be the case, that says there's been undue preference. That would be very difficult to claim that because they've been given super preference in rescue and are now preferred over other secureds, that it was an undue preference or voidable transaction. But it's something that liquidators would look at quite closely. What funding came in? Was it in the best interest of the business?
Yeah. One more thing, Peter. I just want to say something, Marie. Our reality in South Africa is that the market for opportunistic debt funders is very small. So in America, for example, you've got these big distressed funds who put money into Chapter 11 companies, dip loans, and so on. It's a fairly mature market there. Opportunistic investors, obviously, it's risky investment, so they get high returns out of it. There's very few funds here who do it at this stage. So when, as a business rescue practitioner, you're out there looking for post-commencement finance, typically the only people who are going to put post-commencement finance in are either the banks who are already invested in that specific company or the shareholders. We've got one or two funds over here who have started doing distressed funding. It's something that we're looking at as well, but the market is very, very immature. And that's why the relationship with the banks, as Peter's correctly pointed out, is so important. The business rescue practitioner has to have the trust of the banks in order to raise post-commencement finance and to get the cooperation of the banks throughout the business rescue.
I have a question. I don't know the answer to this, and you guys can obviously give it. Have you seen a bank, let's say, who's owed R1 million on an overdraft, come in and put PCF in to settle that and then become secured?
Well, and become secured, yes, we have seen that.
Yeah, so they settle their own debt through PCF finance. So then it would be in their interest to actually become financiers.
Absolutely.
Because
we have seen that, and typically how a bank will advance post-commencement finance is that there'll be an overdraft of, say, R1 million, and the bank will have a session over the debtor book. Once the company's in business rescue and the business rescue practitioner is appointed, then the receipts that come in from debtors are in fact owned by the bank, right? Because of the session on the debtor's book. However, the bank will allow the business rescue practitioner to use those funds in many instances, provided the relationship is good and provided the business rescue plan makes sense. Then that effectively becomes post-commencement finance that is advanced by the bank.
Maurice, there's another point there, sorry.
Sort of mentioned before I forget, sorry to interrupt, is if you're going to put money in, particularly when it comes to employees, and we've had a lot of companies suggest that they need to put money into to settle their employees' salaries, that ought to be done as PCF. So rather put the business into business rescue and then do that so that you become super preferent in relation to those monies. Only last week we had several who had done that, but outside of business rescue, and they were kicking themselves. So the audience also mentioned that to friends and colleagues, that if you're going to be putting money in, put it in as PCF.
Maurice, could I just chip in there because you raised an important point there on the refinancing of an overdraft facility. I'm doing one outside of rescue at the moment, 23 million rand overdraft facility, and that's their only funding. It's the most daft way to fund a company. Overdraft, let's remind ourselves, is to cover working capital. And what we're doing is, and the bank has a mortgage over the fixed property. So what we're negotiating with the bank to do is put that into a proper mortgage loan over a term, and refinance it with additional funding because the property value can withstand it, which is then used for proper working capital. I mean, even it's a good accounting corporate finance adage: do not fund long-term assets with short-term capital. You're going to land up in trouble. So we try and restructure the balance sheet during the rescue such that when we hand it back, it's got a properly structured capital, which should improve the sustainability, prior to business rescue.
Now, Peter, maybe whilst I got you there, I think a lot of people in the audience will be relieved with the moratorium, but what are the sureties they've signed?
It is a question that we always ask, and obviously, depending on the wording of the surety, the lender or the holder of that surety can go for the individual, even though we're in rescue. So it doesn't protect the individual necessarily. As I say, very much depends on the wording of that surety agreement. But if it is such that if it is such that the lender's got to take action and exercise his action against the company first before he can exercise his security against the individual, then the creditor's got to wait in line until the rescue is completed. So it's critical to check out the wording of the actual surety arrangement.
Yeah, because I mean that's also I'd imagine a lot of business owners, their decision as to whether to put in rescue or not will also be determined with the sureties. So I think the audience, have a look at your sureties, pull the sureties out. That's important. Ian, just to you, employees. I think it's something which a lot of people have on their minds. Just in your experience, rescue practitioner and engagement with employees, can you take us through that?
The rescue practitioner engaged with the employees. His first duty to engage with employees is during the Section 148 meeting, which is 10 days after the business rescue practitioner is appointed. The business rescue practitioner then advises the employees as to whether he believes there's a basis of, a reasonable prospect of saving the company. He can invite the employees to form an employees representative committee. But the employees, I mean, the business rescue practitioner doesn't actually have to engage directly with employees if there's a trade union involved. He can then engage with the trade union representative himself. Typically, when there's retrenchments involved, it's obviously a very sensitive process. People are losing their jobs and so on, and it's a process that needs to be handled very carefully. The way we typically do it, and what is very true is that the way we convey it to them is that the only way to save the company is to effect these retrenchments. And should the company be saved at the end of the day, obviously we can look at bringing those people back. But the truth of the matter is the only way to save the company is by effecting those retrenchments, and that needs to be conveyed in a clever and tactful and sensitive way to the employees. Peter, do you have anything to say on that matter?
No, just the other, not anomaly, the intriguing thing in our Act, I suppose it's if we consider how our government's put together, is that there is a requirement in the Act for the practitioner to also engage with the unions, if the unions are involved.
Yeah.
So believe me, the practitioner at SAA is very spending quite a bit of his time discussing with the two main unions that are involved in that rescue.
Correct. So if there's a union involved, then the practitioner is required to engage with a union representative. If there's no union involved, then he's required to engage either with the full body of employees or with the employee representative.
Yeah, and I think it's important for the audience to realize that views have been formulated by labor attorneys that the consultative process, considering the circumstances, will be that much shorter than is the norm. So normally when you go through a retrenchment process, you're looking at weeks to consult, and it's known as a joint consensus seeking exercise to try and see whether the dismissals can be avoided and what have you. The consensus seeking exercise is very, very simple because we know what the issue is, and it's just a question of consulting on ways to mitigate the adverse effects of the dismissal. That's a requirement in terms of Section 189, prospects of future employment, and the like, and methods of selecting the employees. So normally when it just comes to the most common is LIFO, last in, first out. That may be very, very different now, because what one has to have regard to is actually operationally whether the employee is making money. The business rescue practitioner is going to want that employee there because they're commercially and operationally important, whereas others may be less important. What we do once we yeah, carry on.
Sorry, we very seldom use the LIFO method. When considering which employees to preserve, it is literally the employees that can keep that business running, that can work as a skeleton staff with no fat on the bone whatsoever, and keep that company operational while we rebuild it.
Tell me, how are claims submitted to you guys?
We can receive claims via at the first meeting of creditors, at the 147 meeting. We can then invite creditors to submit claims then. Otherwise, they typically submit claims to us throughout the process of preparing the business rescue plan. We typically give a cut-off date by which the claims all have to be submitted, and that cut-off date is normally sort of a day or two before the business rescue plan is published. It's a very short amount of time before the plan is published, but we work within strict time frames, and so we typically keep it open until the business rescue plan is published.
What happens if it's rejected?
Well, there are often disputed claims. There's often a dispute between a debtor and a creditor as to what is actually owed. And we can publish a business rescue plan, and we have done this often, where we have a column that says, this is what the company claims, this is what the company says the claim is. There's a column that says, this is what the creditor says the claim is. Then we have a disputed column. And we allow ourselves then to sort out that dispute whilst the company is in business rescue and whilst the plan is being rolled out. Best, it's obviously better to have all claims resolved before the business rescue plan is published, so that there are no undisputed claims by that time. But the reality is that often there are disputed claims which take longer to resolve than the 25 days in which we have to put a business rescue plan together.
And if you just can't get a vote, so just take us through the votes. Who votes, and what is and what happens if you can't get the vote, you can't get an approval?
Okay, so typically everybody votes. All the creditors vote. There's two classes of creditors when it comes to voting. You've got the independent creditors and you've got the non-independent creditors. Now, the non-independent creditors include your shareholders and directors. Shareholders who might have loans, directors who might have money in the company, and your independent, that's your non-independent creditors, includes that, and your independent creditors is everybody else. So the vote that is required in order to have a business rescue plan passed is 75% of all creditors who vote by value are required to pass the plan. And of that 75%, of those who vote, 50% have to be independent creditors. So the real test is obviously your shareholders and your directors are always going to 99% of the time vote in favor of the plan. The real test is to get a majority vote, in other words, 50% plus one of all your independent creditors. In other words, everybody who's got no connection whatsoever to the company except for the debtor-creditor relationship. Peter, do you have anything to add to that?
Yeah, just clarification there. Well, first, it's as Ian rightly says, it's creditors voting, and that's voting in person or by proxy. So the practitioner can go around the creditor body and get proxies once they've seen the plan. Of course, nobody's voting if they haven't seen the plan yet. You can only do this once the plan is published. And if you can get your proxies in, very often that's quite a simple meeting. If you've got people that take an opposing view, like the one I talked about earlier, the hospital, then that's extremely difficult to get everybody on board. But people can vote by proxy. And then the 50%, and you were saying 50% plus one, it's actually 50% of the 75% have got to be independent. So 2/3 have got to be independent. Yeah, I mean, it can become a bit of a juggling act. You've got to work out who's for and who's against. Clearly, first prize is you try and panel beat those that are against into the for column, because you've done some pre-assessment. I'm not close to the Studderford's rescue, but something horribly went wrong there because the creditors landed up in huge disagreement, and eventually all of them just voted the plans down, whatever plan was put forward. And as we know, Studderford's went into liquidation. So I think it's critical. We would not present a plan and go into a vote without having some idea, and hopefully in the bag, of that the vote's going to go through. If the vote doesn't go through, the practitioner then can ask the body of those present, or ask the body of creditors, if he or she can present an alternative plan, and there's a time limit for doing that. If the practitioner, and obviously then it goes through the same process, a new plan is published and the same process would happen. If the practitioner is silent on that matter, then any of the creditors can step forward with their proposed plan. And if the practitioner believes that it's a workable plan, and that's quite an important point, because if it's just fly in the night or just a plan that only favors one of the creditors to the detriment of the others, clearly the practitioner has to reject it. But if the creditors put forward a plan, then it goes to the vote as well. And if that goes through on the vote, then that is the plan. Also to say that the creditors in the meeting can propose amendments, as can the practitioner. Very often what you do is you publish a plan, and then you find that additional information comes to you that requires an adjustment to the plan, and you can propose amendments to the plan. Those require a 50% plus one vote for it to go in as an amendment, and then the plan voted on as the original plan plus amendments.
Absolutely.
What happens with prescription? Do any of you guys know the prescription of debts during a business rescue? You have 3 years to claim. Now the company's in business rescue. What if you only have a week to claim?
Peter, would you like to answer?
Well, the claim, remember, this is the creditor. So unless these, and it could happen, unless the company's records are in such an appalling state that you've missed, and it would have to be a significant creditor who's missed out of the notification altogether. And that's why it's certainly important to make sure that you're looking at the full body of creditors. Obviously, email is the chosen route of advice, or of notification rather. And once they're all notified, if somebody isn't notified, they would either they'd have the right to go to the practitioner and advise him, even if that's after the plan. And if it was a significant creditor, I've never had a case like this, I don't know about you, Ian, but I would imagine that the practitioner would be obligated to revise his plan and put it to the vote again. If the creditor is completely silent for the period, his prescription would apply. But remember, one of the things in the Act is once the plan is voted on, it is carried as the end result. You can't change it. No creditor can come forward afterwards and say, I didn't vote on the plan, or I abstained, and therefore I don't accept the plan. Once that 75% hurdle is reached, the plan is binding on the entire 100% of the creditors. Now, as I say, the only thing I can think of, and then prescription is not affected in so much as the claim changes, the nature of the creditor's claim. It might be a compromise. It might have gone from payable in 30 days to payable over 3 years. Whatever the reason is, the creditor will be bound by that plan.
And of course, we have 133 sub 3, which reads, if any right to commence proceedings, otherwise assert a claim against the company and is subject to a time limit, the measurement of that time must be suspended during the company's business rescue proceedings. So that would also apply to any time, if whatever the time periods may be in relation to a claim, not only prescription, but outside of that, it could be outside of statute, those time periods are suspended. The question there would arise, what if there's a contractual time period? For instance, as against an insurance company, you have 90 days to claim, or the like. Is that suspended as well? And I imagine from the wording of the section, it would be. Because it says commence, if a right, and it doesn't say a statutory right, it could be a contractual right to commence proceeding, otherwise a certain claim against the company is subject to a time limit. The measurement of the time limit must be suspended, which is also helpful. We still do not have any questions from the audience. Maybe not questions, but if there are any topics that you'd like us to focus on, the PCF is generally, the post-commencement finance is a topic that a lot of people like to dig deep in, but we have dealt with that. The same when it comes to employees. If I think just on the conclusion of business rescue, Ian or Peter, how does it end?
Maurice, typically it would end with filing a notice of substantial implementation. So the plan, the business rescue plan, will set out what constitutes what we call substantial implementation of the business rescue plan. And substantial implementation is exactly that. It's when the plan has been implemented to the extent that it can be considered a success. So it does not mean, substantial implementation does not mean that all creditors have been paid in full as per the plan. Substantial implementation can mean that only a third of the creditors have been paid, or the creditors have been paid a third of the value that's owing to them, but the company is very much on track towards having all the creditors paid. The reality of the situation is that creditors often ask us to keep the company in business rescue until they are paid in full, as is envisaged by the plan. So that obviously makes for much longer business rescue periods in some cases. However, the substantial implementation can be, is often based on, or the milestone of substantial implementation is often based on an event happening, for example, the sale of an asset or the sale of a division or something like that, which brings in money, allows creditors to be settled, and allows the rest of the company to continue operating. So we file there's a standard form that's prescribed by CIPC. It's called the 125.1 form that is that says that the business rescue practitioner signs, and which states that the business rescue plan has been substantially implemented. He files that, and then the company comes out of business rescue. That's in the event of a successful business rescue.
Just one point there to highlight is that it's an intriguing thing, because as Ian rightly says, it says that the plan has been substantially implemented, which could have been achieved, but for accounting purposes, you might still have a technically insolvent balance sheet. So i.e. liabilities on the balance sheet exceed the assets, or you might have unable to pay its liabilities as they occur in the next 6 months, which is Chapter 4 of the Section 4 of the Companies Act. So the practitioner has to hand back, obviously, a solvent company. I mean, it would be daft to hand back a company to the shareholders and the next day a liquidator steps forward and puts the company, or a creditor steps forward and applies for the liquidation of the company. That would be a failure. So you've got to make sure that you substantially complete, as well as is a solvent company and sustainable solvent company.
And I think just to mention there, if it doesn't work out and it has to go into liquidation, part of the COBRA initiative is to convert the business rescue by way of a High Court application into a liquidation, which normally costs in the region of 30,000 rands. We're doing that pro bono for businesses. Idea is, if you come into the COBRA ecosystem, we don't want to get you there, and if you end up there while that conversion is going to take place, and it's on COBRA, at least there's an incentive for COBRA to make sure that your business is salvaged. I just wanted to deal with another, maybe to conclude, very important aspect, and that is why it's important to pick the right business rescue practitioner. Now, you may know somebody who's a business rescue practitioner. Just make sure that they're experienced in business rescue, because there's certain provisions, and this is an important one to end off with, such as a provision that requires the business rescue practitioner to suspend all contractual obligations immediately on his or her appointment. So if the business rescue practitioner does not send a notice, let's say to the landlord suspending the lease, the landlord still has a right to terminate the lease due to non-payment and then evict. There's a case by Barachowitz which actually allowed an eviction in those circumstances. Basically said that the moratorium did not kick in because of that. So when it comes to picking a business rescue practitioner, outside of the COBRA ecosystem, just make sure that the business rescue practitioner is aware of that, because that can be fatal. That could actually be the end of it. So PCF, make sure that you, post-commencement finance, you put in afterwards, and that any business rescue practitioner knows what they're up to. Also, get a business rescue practitioner who's known by the banks, who's respected by the banks, who goes to the banks, they know we've got to listen, as opposed to somebody who doesn't have a relationship with the banks or is not respected by the banks. Also very important. Sorry, Ian, you were going to say?
Yeah, I just said I'm just backing up what you said now. Do your research thoroughly on the business rescue practitioner. I say this in every webinar. The business rescue, the success or the failure of the business rescue is 99% dependent on the choice of the business rescue practitioner. I'm not here to blow our own horns. I'm not here to put our competitors down, but there are a lot of business rescue practitioners out there who are not adequately qualified, unfortunately, to be doing what they do. Please do your homework thoroughly. Speak to big creditors, especially speak to the banks, speak to the big creditors as to who they would recommend, or if you have a certain business rescue practitioner in mind, speak to the banks and the big creditors. Say to them, what is your opinion of this person? Would you be comfortable if we put it into business rescue under them? And most of the time they will give you a direct answer.
Yeah, and what happens if you pick the wrong practitioner, and now you're stuck with that practitioner?
Well, that's the problem, Maurice. It's difficult to get rid of a business rescue practitioner, and if you, by the time you realize that you've got the wrong business rescue practitioner, then it can be too late. You can go to court then to have the business rescue practitioner removed and replaced by somebody else. But we all know that these court processes take a long time sometimes, and they're expensive. So it's something you don't need. You don't need, as a business owner or a creditor of a business, to be faced with a business rescue practitioner who has ultimate control of your company, but who's not suitable. That's why it's so important to make the correct decision right from the start. But yes, talking to your question, you do have the option of going to court to have the business rescue practitioner removed for whatever he's done wrong.
Right. Another thing to consider there is that, and certainly I know this was the case in Studderford's, if you are concerned, not that I think the creditors had a concern about the practitioner in that case, but more that they were concerned about their rights, is the creditor body appoints a practitioner to advise them. And I think that's an important point, because if the practitioner is the wrong practitioner, and Ian's been, I think, quite generous to practitioners. We've had a practitioner who himself filed for bankruptcy. We've had a practitioner who was had up for insider trading, who was fined by the FSCA in a previous life and is now a senior business rescue practitioner. So you are going to get the crooks as well. I mean, it's an unfortunate thing in this industry. But, then if the guy's already appointed, I think it's a wise thing to approach a reputable practitioner just for advice, because if the guy's a crook or incompetent, he's going to trip up, and you're soon going to have a valid case to go to court to have him removed.
Yeah, sure. Great, thanks. Thanks, guys. I think we've concluded for today. Tomorrow we'll be dealing with other questions, so please join us. And if you have any questions specific to your industry, we'll set up a private Zoom meeting with you and your team, and we'll see how we can help there. Or if you have any questions, please go onto the website, get our details, send us emails. And if you have a particular case, if you want to enter into the COBRA ecosystem, send an email to that. You can also email me personally. It's crespi@schindlers.co.za, and I'll get you registered onto the Microsoft Teams space and the war room, where they'll assist you and take you through the process. And hopefully COBRA is going to make a difference when it comes to avoiding business rescues. So thank you very much for joining me. Thank you to the panel, and I'll see you all back here tomorrow. Thanks, guys.